All right, if you're gearing up for the bar exams, let's talk about the one rule that probably causes more sleepless nights than any other: hearsay. It's a beast for sure, but today we're going to tame it. We're going to give you a framework that you can actually use to crack those exam questions wide open.
So let's just jump right into the deep end with a classic bar exam style paradox. A kid answers the phone and yells out, "It's Daddy!" A court might call that hearsay. But in a different case, police raid a house and the phone rings off the hook with people asking for drugs, and that might get in. Now, how does that make any sense? It seems totally backwards, right? Well, this is exactly the kind of knot the examiners want you to untangle. And by the end of our session today, you'll see the logic behind it all.
And here's our game plan to get you there. First, we'll nail down the core rule, the absolute bedrock. Then, we'll find the secret door called original evidence. After that, we dive into the really tricky part, the implied assertions trap. We'll break down the key cases you absolutely have to know. And then we'll wrap it all up in a simple, practical framework you can take straight into the exam hall.
Right then, first things first, you can't play the game if you don't know the rules. Before we can even think about the tricky exceptions, we have to be absolutely rock solid on what hearsay actually is. Let's lay that foundation right now. Here it is, the classic textbook definition, an out-of-court statement offered to prove the truth of the matter asserted. Now, the phrase to underline in your brain is to prove the truth. Everything, and I mean everything, hangs on the purpose for which the evidence is being offered. If you are asking the court to believe that the statement itself is factually correct, ding, 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 you have a hearsay problem.
So why the big fuss? Why does the law get so worked up about this? Well, it all comes down to one word: reliability. A courtroom is all about testing evidence. It's about putting a witness on the stand and challenging what they say through cross-examination. But if your witness says, "My mate Dave told me the getaway car was blue," you can't cross-examine Dave, can you? You can't test his eyesight or his memory or whether he was telling the truth. The evidence is inherently weaker because the person who actually made the statement isn't there to be challenged.
Okay, this slide right here is the absolute key. This is the fundamental split. On the left, you've got the danger zone. The purpose is to prove the statement is true. B said the car was red, is offered to prove the car was in fact red. That's hearsay. But look to the right. Here, the purpose is just to prove the statement was made. You don't care if the warning was needed, you just care that a warning was shouted. The very act of speaking is the relevant fact. That's not hearsay. That's called original evidence.
So let's drill down into this idea of original evidence. Think of it as the #1 escape hatch from a hearsay objection. The concept is actually pretty straightforward. Sometimes, a statement isn't a story about a fact. The statement is the fact that matters.
And just look at how broad this principle is. If someone makes a threat, you're not trying to prove they would have carried it out. You're just proving the words were spoken to show their effect on the listener, to prove duress. The false alibis? The point isn't whether the alibis were true. Of course they weren't. The point is that they were identical, which proves collusion. In every single one of these examples, the words themselves have a direct legal relevance, completely separate from whether they're true or not.
All right, I hope you're buckled in. You've got the basics down, now we're heading into the deep end. This is where the common law gets wonderfully and frustratingly complex. This is the implied assertion trap, and it is a stone-cold classic on bar exams.
And this is the granddaddy of all hearsay cases, the one that perfectly illustrates the trap. A man's sanity was in question. To prove he was sane, his lawyers tried to introduce business letters written to him. The logic was, hey, people wouldn't write these complex letters to a man unless they believed he was competent. The court said, nope, that's hearsay. Why? Because you're using the letters to prove the truth of the writer's implied belief in his sanity. Mind-bending, right? But then get this, evidence that local kids used to shout silly old man at him was allowed in to show he had a reputation for being of unsound mind. The court called those insults simple verbal acts, a very, very fine distinction.
Now let's bring this closer to home with a High Court of Australia case, R v Benz. Picture the scene. It's late at night, two women are on a bridge. A concerned motorist pulls over to see if they're okay. One of the women says this exact quote. A short time later, the body of the other woman, her mother, is found, drowned.
So, your counsel, what do you do with that statement? Is it just a simple brush-off, a verbal act designed to get a potential witness to drive on? Or is there something deeper going on? Is the speaker, without saying it directly, actually asserting certain facts? Fact 1, the person with me is my mother. Fact 2, she's only a bit sick, nothing serious. What's the real purpose of those words?
And the High Court said it was hearsay. They found that the prosecution was trying to use that statement to prove the truth of the fact it implied, namely that the two women were indeed mother and daughter. The court looked behind the literal words, found a hidden, intended assertion, and ruled it inadmissible on that basis.
Look, I know this implied assertion stuff can feel like trying to nail jelly to a wall. It's confusing. So, the best way to handle it for the bar exam is to just learn the pattern from the key cases. Let's put them all into a simple, revision-ready cheat sheet.
See the pattern here? In Walton, its daddy was ruled hearsay because it implied the caller's identity. In Kearley, the calls asking for drugs were seen as implying the caller's belief that the resident was a drug dealer. And in Benz, the statement implied the relationship. In every single case, the common law digs for a hidden assertion of fact or belief. And if the statement is being used to prove that hidden assertion is true, it gets excluded. That is the pattern you need to spot.
Okay, after wading through all that common law complexity, you might be feeling a bit exhausted. But I have some very good news for you. If you're practicing in one of the Uniform Evidence Act jurisdictions, there is a statutory life raft. There is a much simpler way.
The Evidence Act basically takes a big knife and just cuts through all that confusing, pedantic common law doctrine. It replaces the tricky question of what a statement implies with a much simpler, more direct question. What did the person making the statement intend to assert? So think back to the child in Walton. Was that little kid intending to make a formal assertion of the caller's identity to the police officer listening in? Of course not. This focus on intention is a total game changer, and it's your best friend in the exam.
So, let's put it all together. Here it is, your exam day checklist, your 3-step hearsay spotter. Whenever you see an issue, just run it through this process. Step 1, identify. Is this an out-of-court statement, a previous representation? Simple yes or no. Step 2, analyze purpose. Is it being offered to prove the truth of a fact that the maker intended to assert? If you get a yes for both, you move to the final step. Step 3, find an exception. Does one of the many common law or statutory exceptions apply? Follow this structure and you'll put together a logical, clear, and correct answer every single time.
So, at the end of the day, this isn't just a dry, academic hurdle you have to jump for the exam. This goes right to the very core of what you'll be doing as a barrister. Your entire career will be about arguing the meaning of words, what was said, what was meant, and crucially, what was left unsaid. Mastering hearsay isn't just about passing the bar. It's about learning one of the fundamental skills of being a true advocate.